Assistant Professor in Department of Forensic Medicine, Andhra Medical College. Today my topic is about a case discussion, case summary, that is Jacob Matthews versus State of Punjab. Okay. I have titled the topic as Know Your Rights. Why I did so, let me explain. This was one incident that happened last year. A young gold medalist gynecologist Dr. Archana Sharma committed suicide in Dausa, Rajasthan when a case of murder was filed against her under IPC 302 when a pregnant lady died due to a known complication of PPH during childbirth. Okay, this was a real incident that happened. If you see the post, it was posted in Twitter. Down below it is written in her own hands in bold letters, "Don't harass innocent doctors." Okay, there are external factors involved in this case. Like, I had a friend who is from this part of the country. I talked to him about this case. What happened? What is the scenario? What happened? He told me that there are certain people who are interested in these kind of cases, where a small mistake, if done by a doctor, they are not relatives of attenders or patient or anyone, but they'll harass the doctor, they'll threaten the doctor, they'll destroy the doctor's reputation and fame and extort money. That is their primary goal. So these external factors may be responsible for her death. She may have felt bad about that case, and filing IPC 302 murder charges on her is also wrong. For this particular incident, Superintendent of Police in charge of the district was suspended, and some politicians, 2 or 3 politicians in that area were also arrested. But those are external factors. What I'm trying to say is, as a doctors, you should know if something happens, what are the guidelines in our country, how will the case proceed from registering of FIR, and how will it proceed? What will be the investigation process? In which cases, in which sections that they'll file the charges, and all these things you have to know as doctors. Because tomorrow you'll be starting your practice. You'll be having a long practice in this country, most of you, and during that practice you may face similar instances where you have to where you have to face these situations. So I'm not saying particularly that this doctor doesn't know her rights or anything, but the situation might have forced her to commit suicide. But why I'm saying you is, if at all you face or any of your friends face a similar situation, you should know. You should have a basic idea of what is going to happen. What are the guidelines? So that is the reason I have chosen this topic. Okay, let's go into the topic. Jacob Matthews versus State of Punjab and ANR. If you see the Supreme Court cases, there will be and ANR and ORS. ANR means another, ORS means others. In this case, Jacob Matthews versus State of Punjab and ANR. A first information report with Police Station Division Number 3, Ludhiana, whereupon an offence under Section 304A, read with Section 34 of Indian Penal Code, was registered. Okay, the latter part of the FIR states. Let me tell you about what the first part of the FIR states. On 15th of February in 1995, a person was admitted in CMC Ludhiana. I'm not going into the details of the name and all, but a person was admitted into the CMC Ludhiana. He was taken care of by these 2 doctors, Jacob Matthews and Alan Joseph. 2 doctors were taking care of him. On 22nd of February, at night 10 p.m., he developed difficulty in breathing. His elder son was with him at that time. Immediately, he went and reported the same to a staff nurse. Staff nurse called the doctors. It took 20 minutes for them to attend the case. Once they have attended the case, they took oxygen cylinder and put the mask on that person. Okay, the problem was that oxygen cylinder was empty. So that was the problem. So even though he was at there was a mask attached to oxygen cylinder. His breathing difficulty did not subside. In fact, it was increasing. Once they noticed that oxygen cylinder was empty, his elder brother, the complainant elder brother who was with the patient, went to another ward which was beside that ward and brought the oxygen cylinder. In those days, what happens is oxygen cylinders there is a screw mechanism for oxygen cylinders. You need to unlock that so that the oxygen cylinder becomes functional. That mechanism, that screw, to unlocking the screw was not available at that time in the ward. So even though he bought the one full oxygen cylinder, they couldn't attach that. Almost 5 to 7 minutes passed by for searching this oxygen cylinder. In that time, that patient expired. Okay. Now, this was the first part of FIR. Next part. The death of my father was occurred due to the carelessness of doctors and nurses and non-availability of oxygen cylinder, and the empty cylinder was fixed on the mouth of my father and his breathing was totally stopped. Hence, my father died. I sent the dead body of my father to my village for last cremation and the information have come to you. Suitable action can be done. This was his allegation. Okay. Now, a challan was framed by police. It is called as challan in that part. It is usually called as charge sheet also. Charge sheet means, for your understanding, let me put it in a simple way. What happens is when police start their investigation, they'll try to find out how it happened, why it happened, at what time it happened, material evidence, document evidence, everything they'll collect about the investigation. Complete everything about investigation, they'll make a file. That file, after the finishing of investigation, they'll submit to court. That is challan. They framed the charges under 304 AIPC and completed the investigation and submitted the same to JFCM Ludhiana. Once they submit the challan, that JFCM Ludhiana, he will look after the details of the case, whether they should proceed for a trial or not, whether the charges are correctly framed or not, whether the incident really happened or not, everything they'll look. The magistrate will check, and after that he'll say, let's proceed for the case. In this case, JFCM Ludhiana, he saw that charge sheet and said, okay, let's go for trial. Now, what happened is, this doctor, Jacob Matthews, went to Session Court and filed for revision to dismiss these charges, the charges that were framed against Jacob Matthews. Okay, but that Sessions Court is like District Court. District Court, they dismissed his petition, Jacob Matthews' petition. So, after that, he went to High Court for quashing of FIR. Quashing of FIR means, see, first let me clear you, let us understand what we are talking about here. See, this is not question of whether there was negligence or not. The story you heard, this doctor, particular doctor, Jacob Matthews, is not fighting whether he is negligent or not. This whole story is about whether you can charge these things against that doctor. Quashing of FIR means the registering of the case itself is wrong on that particular doctor. So you should not register. That is what he is asking. You should not register this case against me. So this is what we are discussing today. How can you register such a case against a doctor? That is what his question is. So that is what we are discussing. So he didn't go for High Court saying that I am guilty or not guilty. He went to High Court that how can you register this case? Okay, that is what we are talking about. Petition for in High Court for quashing of FIR, High Court dismissed. High Court first listened to his argument. His argument was, let me tell you about his side of story. What he told is, that particular patient was terminally ill cancer patient. He was refused to get admitted by all private hospitals in that city. Okay, but his children were very influential people. They talked with the management of this CMC Ludhiana, and they thought, at least give some palliative care, give some good diet in his last stage of life, so that he'll get some kind of good treatment that is better than home. They thought like that, and influenced the management, and that's why he was admitted in that hospital, and he was being taken care of properly without any complaints. And that particular incident which happened on that day, absence of oxygen cylinder, that is not the doctor's fault. That is what he's saying. That is not the doctor's fault. If it is not the doctor's fault, how come you register a case against doctor? That is what he's asking. It is not doctor's fault. What are the criteria that you choose when you are putting this case against doctor? That is what he's asking. Okay. High Court listened to his argument. His argument was good. What High Court ordered the JFCM is, let the trial begin. Listen to his version of story during the trial. That's what High Court ordered. But High Court did not quash the affair. Quashing the affair means completely dismissing the affair. When FIR gets registered, one crime number will be created, everything. So, completely dismiss the affair. That's what he's asking. That's what High Court told JFCM, that proceed with the trial, but listen to his side of argument also. But he was not satisfied with that. He filed an application for recalling of the order. It was also dismissed. Then there is one option called as special leave petition. Usually if you see newspapers and all, it will be written SLP like that. So he filed a special leave petition. See, all these things, you should know these things, because if you don't know these things, how to fight against in a court of law, you'll be thinking just they put a case against me, then I have to attend court. All these things only you'll understand. Otherwise, there are several provisions for you in the law. You need to understand all those things. Okay. Filed a special leave petition in Supreme Court. And he referred to this case. So whenever they go to Supreme Court or High Court, they'll point out at some cases. These are the things that happened in that case. This is the judgment given in that case. So please give me the same judgment. Most of the times this is how it is done. They'll point out towards a particular case that happened in the past. This case happened like that. My case is also similar. Please give the same judgment to me. So what was the case he was referring to is Dr. Suresh Gupta versus Government of NCT of Delhi and ANR. For this act, this is the judgment. Let me tell you about the case. I'll talk very briefly about this case. I'll ask question whether he was negligent or not. Kindly respond. Okay. See, young boy, he had a simple problem of DNS, deviated nasal septum. He went for surgery, corrective surgery. He was not having any heart ailments, previous history. While having surgery, this surgeon did not insert ET tube. He inserted ET tube, but the cuff size was not proper. That cuff size, it should properly occlude the trachea, right? So that the blood will not go into lungs. That cuff size was not proper. So what happened? During that surgery, blood went inside lungs and the person aspirated and died. So cuff size was not proper. This was the problem. So in this case, the judgment given by Supreme Court was, first let me ask someone. Sanjana, is doctor negligent or not? Yes or no? Yes, you think. Yes. Sit down. So let me tell you about the Supreme Court judgment. For this act of negligence, he may be liable in tort. His carelessness or want of due attention and skill cannot be described to be so reckless or grossly negligent as to make him criminally liable. Liable in tort. Tort law is civil law. See, two kinds of negligence is there. Civil negligence, criminal negligence. For you to understand simply, civil means there will be some fine or you have to pay some money, monetary compensation. Criminal means jail, for your understanding, basic thing. Okay, civil law, criminal law. So, this particular case, what the Supreme Court told is, it is liable in tort. Tort means civil, not criminal. For this case to be considered as a criminal negligence, there should be a gross negligence. This is the first time that they have used the word gross. Grossly negligent. Grossly negligent. So, Jacob Matthews pointed out this point. Now, the 3-judge bench which sat for giving solution for that case, Jacob Matthews versus State of Punjab. They were first in disagreement with what the judgment was given in Suresh Gupta case. Why? Two reasons. Negligence or recklessness being gross is not a requirement of 304A. What is 304A? Simple words, death due to rash or negligent act. Do you see any word gross, anywhere gross in that statement? No. Death due to rash or negligent act. That's it. Okay. So why Supreme Court in the decision judgment given earlier, they used the word gross. Why did they use the word gross? That was the first question. When there is no gross. Second question is, if you are using gross for doctors, how come you are not doing the same thing for other people? 304A is simple. RTA cases, most of the RTA cases will be put under 304A. So for those cases, you are not using the word gross. How come for the same section, it is treated differently for doctors and differently for other people? It should not be done. So these two things were, they are not agreeing with Suresh Gupta's case, judgment of Suresh Gupta case. So they have decided to find a solution for this. These are the things that need to be resolved. Is there a difference in civil and criminal law on the concept of negligence? That is what they wanted to know. Civil negligence and criminal negligence. Is there any difference? Second thing is, whether a different standard is applicable for recording a finding of negligence when a professional, in particular a doctor, is to be held guilty of negligence. So, doctor should be treated in par with other persons when you are putting a case of 304A. Is it so, or doctor should be treated differently? This was the question that that has to be resolved. So they have considered a lot of cases. I'm here I'll discuss a few important cases. First case is Andrew versus Director of Public Prosecutions. Simple lack of care will constitute civil liability, but is not enough for purpose of criminal law. There are degrees of negligence, with a very high degree of negligence is required to prove before the felony is established. This was the judgment. Very high degree of negligence for criminal. Civil, simple lack of care. Negligence is there. See, don't think about whether negligence is not there or not. The negligence is there. But simple lack of care is civil. For you to consider it as a criminal negligence, there should be very high degree of negligence. This was one point that they established. Second case is Syed Akbar versus State of Karnataka in 1980. There is a marked difference as to the effect of evidence, that is the proof in civil and criminal cases. In civil proceedings, a mere preponderance of probability is sufficient, and the defendant is not necessarily entitled to the benefit of every reasonable doubt. But in criminal proceedings, the persuasion of guilt must amount to such a moral certainty as convinces the mind of the court as a reasonable man beyond all reasonable doubt. So, in one book it is written very nicely. I don't know whether you can put it in that way or not. Civil case, the probability of negligence, if it is 50% is also okay. Probably negligent. You can call it a civil negligence. But to call it a criminal negligence, there has to be, beyond all reasonable doubt, they have to establish that there is negligence in that particular case. Okay, in criminal cases. Civil cases, probability, 50% is also okay. Beyond all reasonable doubt means 90% in criminal cases. Third case is Balachandra Vaman Pate versus State of Maharashtra, 1968. It has been held that while negligence is an omission to do something which a reasonable man guided upon those considerations which ordinarily regulate the conduct of human affairs would do, or doing something which a prudent and reasonable man would not do. Simple thing, commission and omission. Doing what you are not supposed to do, or not doing what you are supposed to do. Simple thing, commission, omission, negligence. Conclusions of this case, not my class. The definition of negligence is given in Law of Torts. Ratan Lal versus Dheeraj Lal holds good. Law of Torts means civil negligence. Civil negligence means, again, be clear about this, compensation. Damage, compensation. Directly proportional, thing like that. That holds good in India. Second thing is negligence in the context of medical profession necessarily calls for a treatment with a difference. Why negligence in the context of medical profession necessarily calls for treatment with a difference? Why it is not the same? Let me give a simple example. You took your bike which was having some problem. You took that bike to a mechanic. He told you that one spare part is damaged. You have to replace that spare part. You give him money, he'll replace that spare part and it starts functioning. As simple as that. If he doesn't do that properly, it will not work properly. Can you apply the same logic to a doctor? Like when a patient goes, let's say as simple complaint as fever also. A patient goes to a doctor. There is 99% probability that that fever will subside after treatment. But the problem is you cannot say it for sure that I went to the doctor, I should get alright. If I don't get alright, I'll put a case of negligence. The same thing can happen with other cases, right? Spare part, replacing a spare part, it is supposed to get okay. See, one more example is let's say a simple example, like with lawyers. You go to a lawyer, why? Because you think that you will win that case. After argument, there is 50% chances that you will lose the case also. Because one lawyer will win, another lawyer will lose. You cannot sue every lawyer after losing a case, saying that I went to that lawyer, I thought of winning that case, but I lost. That is what that profession is. Similarly, with this profession, there is biological variability and the patient may not get well in all the cases. So it has to be taken in a different way. A professional may be held liable for negligence on one of the two findings. Either he was not possessed of the requisite skill which he professed to have possessed, or he did not exercise with reasonable competence in the given case the skill which he did possess. Simple thing, he should have good skill and he should exercise that skill. Simple case, do you guys know about Boehm's test? Boehm's test, I thought, what was that Boehm's case in last year, but Boehm's test, simply putting the test for determining medical negligence as laid in Boehm's case holds good in its applicability in India. See, Boehm's test is simple, standard of care. Standard of care should be there. If standard of care is not there, it is negligence. It is completely a different class. I'll teach you. So, simply put, he should have a particular skill. If he is not having that particular skill and he is not exercising, if at all he is having that skill, both will be considered as negligence. Okay, next thing is the jurisprudential concept of negligence differs in civil and criminal law. What may be negligence in civil law may not necessarily be negligence in criminal law. For negligence to amount to an offence, the element of mens rea must be shown to exist. See, simple thing that you remember here is, in that case, Sanjana, mens rea means guilty mind. Okay. For you to prove that criminal negligence is there in a particular case, there should be criminal mind. Criminal mind means there should be intent, right? In that case, Suresh Gupta case, he did a mistake. That is obvious. He did a mistake. Negligence is there. But does he have intention of killing that person? No, right? It's an important point. He did a mistake. That is good. He is not having intention. So that's why this is one of the points that they considered. He is not having intention. So he is not criminally liable. That is the point, if you understand. If you consider this point, doctors will never have intention of killing the patient, right? Mostly. If a patient dies, what will the doctor gain? Let's say if it is a like I was talking about spare part, if the quality of spare part is reduced, he may gain some money, the producer of that spare part. That is different issue. But here, if a patient dies, what will the doctor gain? It is not his intention. Most of the cases, it is not his intention. So think about it. If there is intention, then only we can put it under criminal negligence. If there is no intention, no need to put it under criminal. That is also important point, mens rea. Okay. The word gross has not been used in section 304A IPC, yet it is settled that in criminal law negligence or recklessness, it is to be held must be of such a high degree as to be gross. The expression rash or negligent act as occurring in section 304A of the IPC has to be read as qualified by the word grossly. So from now onwards, for doctors, even though they don't mention about the word gross in 304A IPC, from now onwards, if a doctor is charged by 304A IPC, that means there is gross negligence only. For doctors, we have to read it with gross. Rash or negligent, rash or grossly negligent act. For doctors only. To prosecute a medical professional for negligence under criminal law, it must be shown that the accused did something or failed to do something which is in the given facts and circumstances no medical professional in his ordinary senses and prudence would have done or failed to do. Simple thing. Again, I told you before. Doing what you're not supposed to do or not doing what you're supposed to do, almost negligence. Res ipsa loquitur. Again, one more question. Res ipsa loquitur means, Imadir? Res ipsa loquitur. Truth speaks for itself. Fact speaks for itself, right? If you understand the word res ipsa loquitur, let me ask you, res ipsa loquitur holds good in civil cases or criminal cases? Criminal cases. Both civil and criminal. Okay, I'll explain. The res ipsa loquitur, the thing that they gave examples usually is a patient was supposed to have amputation on right leg. He went to the theater. By mistake, he was amputated on left leg. So, that is the common example usually teachers will give. You need not argue about that case, right? You go to the court, it is quite obvious that something was problem with my right leg. The doctor removed my left leg. Simple thing. Now, if you tell me, is it good for civil or criminal? Usually what you students think is it holds good in criminal cases, but it is not so. It holds good in civil cases. Civil cases, why I told you earlier, damage is almost proportionate to compensation. Here again, criminal, there should be intent, right? There was no intention to remove his case. What will the doctor get if he removes? Not in this particular case, I am telling you in general. Damage is directly proportional to compensation. There is huge compensation, there is huge damage, compensation will be huge. Same, res ipsa loquitur will hold good for civil cases. But irrespective of damage, if the damage is small also, if there is intent to cause that damage, it becomes criminal. You cause it with criminal in mind, willfully causing that damage. So, damage, res ipsa loquitur is damage is more, compensation. Obviously, compensation should be more. So, it holds good for civil, but there are exceptions for in this case. So, what Supreme Court opined is, we agree with the principles of law laid down in Suresh Gupta's case and reaffirm the same. First, they were in disagreement. Now, after going through all these discussions and cases, they now agree with the principles of law laid down in Suresh Gupta's case. In it, we may not be understood as having expressed any opinion on the question whether on the facts of that case the accused could or could not have been held guilty of criminal negligence, as that question is not before us. Clearly, the question is not about whether Jacob Matthews was negligent or not. That is not the question at all. So they are not going to comment about that. See, if you are interested, read this particular book, Errors, Medicine and the Law by Alan Murray and Alexander McCall Smith, which has been cited with approval as Dr. Suresh Gupta's case. He talks about the errors, the negligence and all those things. So now, there is a need for statutory rules. Why is there a need for statutory rules? According to Supreme Court, the investigating officer and the private complainant cannot always be supposed to have knowledge of medical science so as to determine whether the act of the accused medical professional amounts to rash or negligent act within the domain of criminal law under section 304A IPC. What is it? See, when a patient is taken to hospital by his attendants, what will they think? They think that he'll get better and he'll come out. That is what he thinks. Okay, if the person dies, it doesn't, that particular patient, attendant or a near relative, he doesn't have idea about why the person died. He just thinks because the patient died, it is the wrong or a negligence of doctor. That is what he thinks. Or else, if he goes and complains the same thing about this incident to a police think, like in that case, particular case, a pregnant woman, she went to hospital. What will they usually think? She'll come out with a baby and healthy mother. That is what they think. If they die, if that woman dies, police will also think the same. It should not happen, right? If they died, it must be the wrong or negligence of doctor. That's what they think. So they don't have idea about what can go wrong, how can it go wrong. So this is one important point. For negligence case, if there is an accident, police can investigate in a particular way and understand how the accident happened, who came in a wrong route, who was driving rash and negligent way, who was overspeeding. Everything police will understand. That is because it is their domain. It is medical knowledge is not their domain, right? So they don't know. That is one point. Second thing is the criminal process once initiated subjects the medical professional to serious embarrassment and sometimes harassment. At the end, he may be exonerated by acquittal or discharge, but the loss which he has suffered in his reputation cannot be compensated by any standards. This is one more important thing. You guys are not yet started practicing, so you may not understand. I'll tell you a real story that happened in my town. What happened was a famous gynecologist. She was having roaring practice. The thing is not even medical negligence. He was charged with some other case, which was not even related to medical practice. After she was charged with that particular case, she was charged with some money laundering or something like that. She completely lost her practice for almost 10 years, which was even not related to medical negligence. One of my friend was telling me, he's an orthopedician. One case that he gets, that if at all gets infected, the case if he does surgeries, right? One case if it gets infected, the news will spread so fast that for the next 3 months, he'll not lend us to human beings. Is probably the noblest of all, and hence there is need for protecting doctors from frivolous or unjust prosecutions. So, Supreme Court, why they wanted to protect doctors is because medical profession is such a noblest profession. Doctors should be protected from frivolous complaints. That is what their intention is. So they have put 3 guidelines. Okay, please remember these 3 guidelines. This is the whole purpose of the class. Okay, 3 guidelines. It is very important for you to remember. Not only for you, if at all your fellow doctor asks for advice, give them this. A private complainant may not be entertained unless the complainant has produced prima facie evidence before the court in the form of credible opinion given by another competent doctor to support the charge of rashness or negligence on the part of accused doctor. So, if at all he thinks that there is negligence on part of the doctor, prima facie evidence should be produced before the court. Prima facie literally means first intention. Okay, first impression. First impression is, that's what the word means, prima facie, first impression. First impression, and in legal terms, it means it holds true unless otherwise it is proved wrong. Okay, the thing is, if at all you think there is some negligence on part of the doctor, let me tell you, if at all something happens in an accident, you see a person driving rash and negligently and causing an accident, you can immediately go to the police and say, sir, this is what happened. Police will arrest that person. That is not the case in this medical negligence. Medical negligence, that prima facie evidence should be produced before the court in form of a credible opinion given by another competent doctor. Then only you can go for framing charges. Okay. This is one thing. Second thing is the investigating officer should, before proceeding against the doctor accused of rash or negligent act or omission, obtain an independent and competent medical opinion, preferably from a doctor in the government service qualified in that branch of medical practice, who can normally be expected to give an impartial and unbiased opinion applying Boehm's test to the facts collected in the investigation. So, because that police person who is investigating officer, he doesn't have any knowledge about the case, and also the complainant, he is also a lay person, he doesn't know anything about the case. Opinion should be sought from a doctor who is competent enough to know whether there is negligence on the part of doctor or not. He should be independent, and he should be competent enough, and preferably a government doctor, like professors of particular specialty. They can give the opinion. They'll use the Boehm's test. Boehm's test, I told you, standard of care will be applied, and based on that they'll give opinion whether there is negligence or not. Based on that, police can proceed. So this is very important. Police cannot make the decision on their own. They have to take an opinion from another doctor. Third thing is, doctor accused of rashness or negligence may not be arrested in a routine manner simply because a charge has been leveled against him. Another very important thing, if at all something happens, you see in the media or somewhere else in the movies, immediately going and arresting a doctor. It should not be done. Doctor cannot be arrested unless they feel that doctor is hindering their investigation, or doctor will leave the country. Then only they can arrest the doctor. Otherwise, they should not arrest the doctor, because that will destroy his reputation as a doctor. Unless his arrest is necessary for furthering the investigation or for collecting evidence, or unless the investigating officer feels satisfied that the doctor proceeded against would not make himself available to face the prosecution, unless arrested, the arrest may be withheld. So this is one important thing. He should not be arrested. Final judgment, what did they give? Probably the hospital may be liable in civil law, or may not be. May or may not be. We express no opinion thereon. But the accused appellant cannot be proceeded against under section 304A IPC on the parameters of Boehm's test. So, first thing, the oxygen cylinder was absent. So, they may be tried under civil law, and they may be or may not be punished, because they are not, it is not the question here. It is not the question, so they are not talking about that. They are talking about whether the appellant, which is Jacob Matthews, can be proceeded against 304A or not. No, he cannot be. They applied the Boehm's test here and said that they cannot frame charges of 304A IPC on the doctor. Prosecution of the accused appellant under section 304A by 34 IPC is quashed. So that FIR was quashed, and these guidelines, Supreme Court ordered the central government to make an act out of it. I think it is in the process still, but there is no act as of now. But finally, the judgment is the FIR was quashed. It is not the way to charge frames, to frame a doctor under 304A IPC. These are my references.